pleases the Court. My name is Gary Kreep. I'm an attorney with the United States Justice Foundation. I'm here to represent Mr. Drake and Mr. Robinson and those clients alone. It is the purpose of our appeal, which is one of the two appeals combined for hearing today, to seek a remand back to the trial court so that we can separately pursue a resolution of this issue so that we can have the case ruled on the merits and not dealt with on the various technical issues that have been raised or on issues that relate to plaintiffs, not my own. As part of my presentation, I will only be dealing with the parts of the ruling by Judge Carter that deal with my clients, as there's a variety of issues raised by the other plaintiffs which I have no stake in.
Could you make clear right at the outset what relief you're seeking?
Yes, we're seeking a remand back to the trial court so that we can
ultimate relief.
Ultimate relief. We're seeking in our proposed second amended complaint that the court reach a determination as to whether Mr. Obama is eligible to serve as President of the United States. That is the ultimate relief we are seeking.
And what remedy flows from that you are seeking?
Well, we're seeking simply a declaration that that is so, if we're able to present the evidence to the court to prove that.
And then what would you expect, or what are you asking the federal district court to do assuming it were to issue that declaration? What would be the next thing that would happen?
Well, the next thing that would happen would be that if the federal court system, because this will go all the way to the U.S. Supreme Court no matter what.
Well, let's just talk about where we are. Yes. Well,
if the court were to remand it back and we went through the procedures and had a trial on the merits, and the court found that Mr. Obama was ineligible to serve in the office, it would be our expectation that the office would ultimately, not necessarily by the court, but the office would be vacant and Mr. Biden would take over as President of the United States pursuant to, I believe, the 20th Amendment.
Thank you.
Now, your clients are former candidates. Is that who they are?
Your Honor, Mr. Drake, Pastor Drake, was in 2008 the vice presidential candidate of the American Independent Party on the ballot in California. My other client is Markham Robinson, who was at the time the chairman of the American Independent Party in California. And pursuant to the Hollander decision, both such individuals, Mr. Robinson on behalf of his party and Mr. Drake as a candidate, have standing to challenge the
But the case was filed after the election was over.
Yes, ma'am, I'm aware of that. I was not involved.
So why do they have standing? Why are they any different than anybody else at this point?
Well, because, first of all, Your Honor, I can't speak to why it was filed after the election.
I'm not saying why. I'm just saying because it was filed after the election, they no longer have an interest in the election. The election's over. So what is it that distinguishes them from anybody else?
Well, Your Honor, first thing, this is a matter that
They're not asking the election to be rerun. They're not declaring that they want to run in the next election. So what's their role here?
Well, we're not asking that the election be rerun, Your Honor.
Right.
We're not asking that the government be shut down.
And you're not alleging that you're not saying that you want this relief because you're planning to run next time.
Well, it's premature, Your Honor, to even speculate whether Mr. Drake would run next time.
Okay. So you're not alleging that. So why are you different from anybody else?
Because this matter, well, first of all, because there is a ruling that they could challenge it from a federal court, number one. Number two.
I'm sorry? What case is that?
The Hollander case, Your Honor.
Wasn't that somebody who was challenging who brought the case when there was an election pending?
Yes, Your Honor, but it wasn't a candidate. It was a general citizen, and that was the basis on which they lost the suit. But the point is, Your Honor, this matter could come up again. We could have, again in 2012, the issue of Mr. Obama, who has already declared for re-election and filed his papers with the Federal Election Commission, running for president, and we still have the same issue. Is he eligible to vote?
But you would be able, the other half of it is incapable of review. It's likely to repeat incapable of review. That would not be incapable of review. Then somebody with standing could, in the course of that election, presumably raise the issue if they wanted to.
if we want to run this whole thing all through again, Your Honor, the facts.
Nothing's been done so far here. All you've done is you filed a complaint, and the district court has challenged standing. That's all we're here on today.
Yes, Your Honor.
So running it all through is not, doesn't seem to be a consideration. The question is, on standing, you can't argue that it is incapable of review. That's the only point I'm trying to address.
Okay. But I have other grounds for requesting remand by this court, Your Honor.
All right.